Hi, everyone. Excited to be back with you on the Conflict Counselor podcast in our new season. I'm your host, attorney mediator Chris Capocia from the 47th District Court in Michigan. Last time, we shared tips on how landlords and property managers can avoid common disputes with their tenants. Today, we'll turn it around and discuss what tenants can do to avoid these disputes with their landlords, specifically concerning the security deposit, rent and utility charges, repairs, environmental hazards, and disturbances. What makes this episode all the more relevant, as I mentioned in the last episode, is that nearly a third of American households are in landlord tenant relationships. So let's get right to it. As we said in the last episode, return of the security deposit is the number one issue in landlord tenant disputes. According to law, the security deposit is the tenant's property and must be refunded upon termination of occupancy. Now, landlords will often make deductions against the security deposit for property damage, cleaning, and unpaid rent and utilities. Tenants must timely object in writing to any unwarranted deductions. A timely objection will force the landlord to negotiate with or to sue the tenant to resolve the issues. Failure of the tenant to object to unwarranted charges could result in loss of the security deposit. To protect against unwarranted charges for property damage and cleaning, tenants should note the condition of the premises in writing on the beginning inventory checklist and take pictures. This evidence will often show that such damage and soiling were pre-existing and not the current tenant's fault. Also, payment records and receipts may be used to contest unwarranted charges for rent and utilities. And tenants should beware. Often such charges are confusing because they may be prorated or paid in advance. The following tips for tenants concern the requirements of habitability and quiet enjoyment. These fancy legal terms simply mean that the landlord or property manager must ensure that the premises is livable and peaceful for the tenant. This includes making necessary repairs, mitigating environmental hazards, and alleviating disturbances. As to repairs, they must be made by the landlord in a timely and safe manner. Regarding environmental hazards, the premises must be free from rodents, insects, mold, and other hazards. And the tenant should not have to put up with loud music, partying, or other disturbances caused by neighbor tenants or the landlord. Note that for any of these common issues, tenants should make a picture record as appropriate and follow up with the landlord in writing until the problem is resolved. Also, depending on the jurisdiction, the tenant may withhold rent as an incentive for the landlord to remedy these types of problems. As to withholding rent, however, tenants should seek legal advice and proceed with caution. Finally, in my experience meeting hundreds of landlord tenant cases, good communications between the parties is key to preventing and resolving most disputes. Well, I hope these tips for tenants are helpful. As always, I welcome your comments on this topic and on life in general. Next time, we're going to discuss the source of much of the conflict in our lives, and that is our unfulfilled need to be heard. See you then.